regarding punishment. That's standard. 17.
Your Honor, just as a point of clarity on 16, I think Your Honor is correct. It is the law of the state of California. However, just for clarity purposes, I think we are entitled to tell the jury this is a serious matter, even though it's a misdemeanor. It is a criminal matter, and the jury should take the evidence very seriously and treat the matter with the attention it deserves.
I don't think so. Yeah, I think so. I don't think that talks about punishment.
Yeah, okay.
People agree?
Agree. The seriousness of the charge is
Sure.
fair game. Punishment words such as jail, prison, incarceration,
Sure.
fines, whatever they may be, those are
Sure.
strictly relevant.
Right.
I just wanted to clarify, Your Honor.
Okay. All right. Okay. Request to quote jury instruction, Juan Dyer.
I believe the court has previously ruled on this.
Yeah.
And just for clarity purposes, I think 1092 probably is not relevant. That's, I think, a Scrivener's error, correct? Calcrim 1092, which is a jury instruction you say you're going to seek to quote from. I think this involves an offense that's not relevant. It's not
That was my mistake, Your Honor.
Okay.
Okay, but I did want to clarify, we are entitled to also quote from 1800. So I think 200, 220, 1800, which is the instruction for petty theft. Is that correct?
Yes.
People think that's fair. No, fair game, Your Honor.
All right. 18, people move for permission to use the court room well. Yeah, that's granted as to both sides. Obviously, again, we're being electronically recorded, so if you're going to move about, you need to make sure that we're going to try to provide you the wireless microphone so you may make sure that you are speaking to the microphone and that you're recorded. Okay, number 19, any allegations made against the prosecution be made out of the presence of the jury regarding prosecutorial misconduct or any Batson and Bueller challenges. The court is going to grant that, and that's with regard to, it goes both ways.
Your Honor, just a point of clarity on that one. I have no disagreement with the granting of that motion, but one of the things we will do is obviously impeach the prosecution's witnesses and suggest the prosecution is overbroad. That pursuing these particular defendants is inappropriate given that they're innocent of the charges that have been filed against them. So I just want to clarify, impeaching the prosecution's witnesses, suggesting this is an overzealous prosecution, I don't think is accusing the prosecutors of misconduct. It's just kind of the nuts and bolts of what you do as a defense attorney. So,
Quite frankly, accusing the prosecutor of being overzealous is, in fact, something that's improper. Pointing to these defendants and saying that why are these defendants being prosecuted is something that can run afoul of that law very, very easily. We're not here to decide anything other than what happened on that date and why it happened. And the fact is, how we got here to court is often irrelevant. The court reads to the jury instructions in cases where people are incarcerated. Don't take the fact that the defendant is incarcerated to mean anything. You have the presumption of innocence. We have all those defense side of things. Well, there is a little bit that works the other way as well, and this is that. They're not allowed to look at the prosecution and say, because you're prosecuting my client, you're overzealous. They're allowed to say the facts, in their opinion, which quite frankly is wrong, but their facts in their opinion show they're not guilty. They're allowed to say that, so be it. But they're not allowed to say anything about overzealous prosecution prosecuting these defendants. That would be error.
I'm not aware of any case authority or statutory authority suggesting that that is the case. I think every defense is in many cases, in many ways, an allegation of overzealous prosecution. Certainly I'm not going to give personal insults of opposing counsel, but even just impeaching the witnesses of the state for bias in many ways could be an implicit argument that this is an overzealous prosecution. We believe the witnesses in your case and presented by the state are testifying in ways that are unfairly targeting our clients. I think that's part of the nuts and bolts of any criminal defense case. I can't see how we could possibly deny that side of line of questioning or argument.
Your Honor, that is asking the jury to consider a fact's not on an evidence, but my office is just conduct in charging them. This is not a fact regarding what events happened on September 28th. It's
Well, let me say it this way. I don't know what kind of arguments that's going to be presented, and so when those are presented, the people's entitled to raise an objection. But I think what the people is indicating here is that if there's going to be any accusations of prosecutorial misconduct, as well as Batson Wheeler challenges, that they may be made outside the presence of the jury, and the court agrees with that. All right. Okay, number 20. Exclude evidence that the government has unlimited time resources. I don't know that there would be such arguments, but
just as it would be improper to, or suggest, as we haven't gone on to all lengths because the government has
well, let's just say if there's is an argument or if there's a point made about that, you can raise an objection, and I think the objection will be sustained because that would be lacking foundation. 21. Okay, any is there any real evidence that has not been previously disclosed?
Not that we need
All
to.
right.
Your Honor, the only exception to this is, again, we've had a last-minute expert witness disclosed to us on the Friday before trial. They're going to be testifying in rebuttal potentially. There may be other documents that we have to submit and present to the jury as a result.
Yeah, other than what we already talked about. Is there
Okay, so
anything else?
responsive documents to Mr. Sutton's testimony, I certainly think we should be entitled to produce. I don't think there are any other documents that we haven't disclosed within the statutory timeline of 30 days. The other thing I'd request, and maybe this is an appropriate time to make this request, is to the extent that Mr. Sutton is going to testify in rebuttal, I think we should be entitled to bring our expert witness back, because we still have no idea what he's going to say. Our expert can't be prepped to respond to him in any way. We have no idea what he's going to say. So if he testifies in rebuttal, I'd respectfully request an opportunity to engage in sir rebuttal and to present any documents our expert may be able to provide in response to Mr. Sutton's testimony, given that I still have not heard the audio recording of his witness statement.
Well, let's cross that bridge when we get there, but I think that's fair. If there's testimony and rebuttal that sir rebuttal testimony is warranted, the court will entertain that motion for sure.
Thank you.
Okay.
Our request is just that goes both ways, especially with the recent history of the prosecution trickling out new information from Mr. Sutton throughout the course of these last few days. That is just my concern.
Well, my understanding is, I understand that the people's produce late evidence regarding the expert, and the court's already excluded that in their case in chief. Right, but at the same time, they've already produced the evidence, even though it is short notice. I think the issue we're going to have here is, I certainly don't want to have, with regard to item number 21, is that whether it's in sir rebuttal or it's in rebuttal, we have completely new evidence that had not been disclosed. All right, and so if that's the case, I think that's going to be a problem, that we can address that, cross that bridge when we get there. 22, produce testimony, motion to exclude testimony regarding chickens' medical conditions. Okay. Not substantiated by expert witness reports.
Just any further or condition regarding the chicken that hasn't been disclosed to the people as of now.
Good. Well, I don't know, is there any? We'll just reserve that if anything comes up.
Yeah, Your Honor, we've met all of our obligations in
Sure.
1054.3. We provided abundant number of documents, expert reports, and statements.
This is not in regards to any of those.
We just finish. Can I finish?
Good. All right.
If there is anything else out there,
Sure.
I understand the argument that it should be excluded, and certainly we just made an argument that evidence needs to be excluded based on late disclosure. I'm not aware of anything that we
Good.
could present. And if there is something that ends up getting presented, you can try and object to it, but I think we provide you everything we have.
Understood.
And
Right.
I think it's voluminous.
23 people request, I think we already addressed
Yeah.
that. Each side gets, people gets 20, and defense gets 10 joint, and 5 each separate. 24 defendant statements be deemed admissible unless they're offered by the defense. They would be admissible unless they're offered by the defense in their case in chief, without the defendant testifying.
I would just say that if it comes up, object,
Sure,
it's contemporaneous objections.
I agree.
Yeah, it's
Stay
too
with
broad
that.
to say all defendant statements. If it is a statement against party interest, I understand there's an
Sure.
exception, but it really just depends on the particular statement that the state attempts to introduce.
All right, so that's it. Looks like anything else, Mr. Atwell?
Your Honor, if I may, we'd like to revisit the question of the admissibility of the people's case in chief of a recent expert witness. Understanding is the court has refused the people's ability to present this witness on the grounds of late discovery. The catch is this: the discovery was provided forthwith when obtained by the people. People went out and obtained this expert, quite frankly, value being such a non-issue in this case, we didn't anticipate the need for it. Now, this witness's statement, this witness was not in the possession of the prosecution team. None of this provided was under the discovery rules in the possession of the prosecution team until we got it and turned it over. So to characterize it as late discovery, I believe is actually an abuse of discretion, is beyond the pale here. Counsel has made it very, very clear that value is an issue. I don't think there's any dispute that the testimony of an executive from the company who had lawful possession of the items in question would be relevant to the issue of value. Now, the only question then becomes one of late discovery. If this were something that was procured in 2001, 2022, and sat in a file somewhere and just wasn't disclosed for months, yeah, there would be an issue. That's not what we have here. The people went out, sought it, got it, provided it, and it's not late discovery. So we're asking the court to reconsider the issue of excluding the witness in the people's case in chief. Quite frankly, I think it might be a moot issue because eventually the witness is going to be presented in rebuttal because defense counsel made it clear they're arguing value. That said, in light of Penal Code 1118, it is important that the people present value in our case in chief. So we would ask to reconsider that issue.
All right. Those arguments have been entertained. The court would stay with its decision. The basis of the decision is that it's not just late discovery. I think Mr. Elwell indicated, and Mr. Colby, you just also indicated that value is always an issue. And whether you anticipate that's going to be disputed or not, it's not an excuse.
Well, Your Honor,
so,
I'm sorry to interrupt, but if I may, the whole crux of late discovery is that it was in the possession of the prosecution team and then not provided in a timely fashion. This is a situation where when it became in possession of the prosecution team, it was provided forthwith. And I think that's the issue that might have been missed here, is that oftentimes in cases there's always further investigation done, quite frankly, last minute. Sometimes it turns up something relevant, sometimes not. If I were to go out tomorrow, if a witness were to approach me tomorrow and say, I was there, I saw this, and I said, okay, and I told defense counsel the next day that I have this new witness who just told me things, then as far as excluding under late discovery, that would be a question. Now, there's other remedies that can arise if defense counsel needs a continuance because of this expert. That can be discussed. That said, though, excluding for late discovery grounds, I believe, is an abuse of discretion. And the only question then becomes, is it relevant? And it is relevant under 350, 351, as the court indicated value is relevant. So it should be admitted at this time, and we're asking for to reconsider on those grounds.
as the court was saying, value is always an issue. And so if it's a witness that was just discovered, that's a different story. But as I understand it, this expert witness was retained at the very last minute. And so if it's an issue where it's anticipated the value is going to be the issue, the witness could have been obtained much, much earlier and could be produced by the defense. And so the court will stay with its decision. Again, it might be a moot point, but we'll see.
But once again, Your Honor, when the people obtain it, the people have no duty to search. The people have no duty to produce all evidence. The people have no duty to go out and find new evidence. And that's essentially what happened. When we realized defense counsel was going to make such a big deal about such a clear and convincing point, in our opinion, then we said, okay, well, let's find somebody who can actually tell us what the truth is here. So we ran out and found somebody. We provided it forthwith. So the question of when...
That's why you're gonna have him potentially come in as a rebuttal witness.
Right, but the question of when the people sought to seek out this information is not relevant, because the only relevant question under the discovery laws is, was it in the possession of the prosecution team? This is a private witness. The information was not in possession of the prosecution team until we received it and provided it forthwith. So it is, I stick with my position. I'm just making that very, very clear.
Okay, all right, objections noted.
Your Honor,
Okay,
I
anything
just
else?
realized we actually did skip one of the motions in limine filed by the prosecution. Maybe I should be not bringing this up because it is their motion, but it's the motion to exclude the testimony of witness Celeste Yamada. I think my understanding is because Ms. Yamada's testimony is very similar to the necropsy, you're denying that motion as well and allowing us
We
to...
did talk about that. I thought that was part and parcel of the motion. Is that something different?
Celeste Yamada, Your Honor, just to give you a sense of the proof we hope to offer with her testimony, she is a fact witness of the condition of the animals in the minutes after the animals were removed from the slaughter truck. So to the extent value is at issue, she can testify to the condition of the animals. The prosecution's argument that this is evidence that is 7, 8, 9, 10 days is simply not correct. She saw the animals immediately afterwards. She's a fact witness that's directly relevant to this trial, and so for those reasons, we'd oppose the state's motion.
Mr. Elwell, anything else? Mr. Cole?
Only again that our testimony would be an observation after the incidents, and it wouldn't go to the good faith of the defendants prior to that and for the remaining issues. Remaining defenses, Your Honor.
And again, Ms. Yamada is testifying not just to the mistake of law or specific intent of the defendants, but more importantly, she's testifying regarding the condition of the animals and the medical care given to them after they were removed.
Well,
As the
the courts
primary
I think
caretaker.
the court's already found that the necropsy reports come in, right?
That's
That's
right,
to the issue of value. So I would agree her testimony would be relevant to the issue of value.
Thank you, Your Honor.
All right, at the 4 o'clock hour.
So we have a couple motions as well. that we
Okay.
have, because there are motions filed on behalf of Ms. Santurio and then some motions filed on behalf of Ms. Paul as well.
Okay.
Just a few small ones.
Okay,
One of them is just asking the court to issue an order to the prosecution not to refer to Foster Farms or any of its agents, associates as victims. That is an issue to be proven in court. And so I just ask, Your Honor, to instruct the prosecution and ask the prosecution to instruct the witnesses not to call Foster Farms a witness, the victim of this offense, because that's a determination to be made by the jury in this case.
Mr. Colby.
Respond to that in 2 ways, Your Honor. In terms of closing argument, I believe that's a different discussion than in terms of during the evidence. Closing argument, I believe it's wholly fair game to use the word victim. We likely will do so. During the course of the trial, I agree in part with defense counsel that the term victim is generally something we try to avoid, and we definitely don't want it to be, I'll use the word weaponized. We don't want it to be a word that's used to try to prejudice the jury. We don't intend to do so. My concern always with this motion is because as criminal prosecutors, we often talk in terms of victims in our office. Every once in a while, we'll use the word victim. I don't want to be in a situation where if the word victim slips out once and that's it, that it creates a big issue with the trial. So we're opposing the motion on that grounds, but spoken to my co-counsel before, we don't actually intend to use the word victim during the course of the trial, but it may come up once or twice by inadvertence, so that's our only concern.
Yeah, and sometimes the court uses too, but I'm careful to use the word allege in front of the victim. Okay, so the motion is granted, but permitted during closing argument.
And we also have a motion in limine to prohibit the use of any testimony or evidence of other bad acts. In discovery, the prosecution has provided a rap sheet for my client. And it involves all nonviolent protest activity over a 20-year time period. Don't think it's relevant to this matter, has no probative value to the offense that's allegedly been committed on September 28, 2021. I think, well, 1101 doesn't allow character evidence, and the character evidence we're trying to introduce is an exception generated by 1102 in Supreme Court case law, but otherwise character evidence of this sort should not be admissible in court. So we just moved this court to grant our motion to exclude any evidence of other bad acts or other crimes that either defendant might have committed or might not have committed over the course of this trial.
That wouldn't come in the people's case in chief, but I suppose it would be rebuttal or impeaching evidence if character evidence of the defendants come in, wouldn't they?
I think under 1102, it specifically says that if defense presents character evidence, the people are allowed to produce character evidence in rebuttal.
Right.
Not making representations about what will be offered. It's just that once they do present character evidence, if they do, then we have the opportunity to rebut under 1102.
I agree with that. Opening the door, if to the extent we present character evidence, they can rebut it only on the issues that we present.
Sure.
Not on broader issues of a protest that occurred 20 years ago that Ms. Paul may have been a part of.
Well, I don't think people intend to go there.
No, I don't. I mean, and quite frankly, I don't expect this to be an issue. I mean, it would only be an issue if defense counsel were to come in and say that my client was in the wrong place at the wrong time and has never been involved in any protests. If we hear something like that, obviously that would change this whole landscape. But we're not expecting that to be an issue at all, except potentially under 1102 once the defense brings in character.
And so I take it the motion is granted, at least for the purposes of the prosecution introducing character.
Motion is granted for that purpose.
Okay. And last, I know this is a little bit of an unusual and creative motion, but I think there's been a lot of evidence recently about the appropriate just seating of defendants in a criminal case, and in particular, there's a Yale Law Journal article that was published a few years ago in 2006 suggesting courtroom arrangement is something for the judge to consider in ensuring that every client and every defendant has a presumption of innocence. I think it would be appropriate to give defense counsel an opportunity to sit near the jury, because when someone is more physically proximate to a defendant, they're more likely to trust them, less likely to think they're dangerous, more likely to be able to kind of observe their mannerisms and their body language. The Supreme Court of the United States has said that the court is entitled to look at any sort of courtroom procedure to ensure the presumption of innocence is maintained, because it is such an important principle in our criminal justice system. So I would just request that we have the opportunity to sit at the table closer to the jury at least half the time. If we switch back and forth, I'm fine with that. But I think it is prejudicial against our clients that we so physically remove from the jury while the prosecution is sitting right next to them. And I know it's an innovative motion, but I brought it up in other cases and it's been granted. So I wanted to bring it in this case.
I have not heard it before. It's true.
I haven't heard it before in 20 years. I've never seen that happen. The courtroom arrangements are within the full purview of the court. And the court, I believe, can do whatever it believes is appropriate. That said, defense counsel's request is essentially they're going to trust my clients more if they sit next to them. Under Article 1, Section 29 due process, wouldn't the same be true for us? Then we get into this back and forth, the switch of seats. It really, I think, is something unnecessary. I don't believe any juror rationally is going to see the fact that a defendant is sitting 3 feet or 6 feet closer to them as an issue, especially in this case when we're talking about out of custody defendants. To me, it would just create logistical confusion, but it's up to the court.
Judge, it's just a practical matter, maybe because I'm stuck on the side of the table.
Yeah.
There's slightly more space over there, so maybe if the court wants to consider that.
Counsel is very well spoken and articulate. I can hear him fine.
Well, I'm more so concerned about being stuck in the corner.
And I would just say that the Yale Law Journal article, should the criminal defendant be assigned a seated court, and the other studies we cite in our motion suggest that courtroom arrangement actually does matter for the presumption of innocence. That when you're more physically distant from someone, you become more emotionally distant, and it's fair for us to be able to switch back and forth at least.
Well, I don't want you to switch back and forth, okay? But if you want to sit to my left, that's fine with the court.
Okay, great, thank you, Your Honor.
Well, if we want to sit there too, under Article 1, Section 29, we have due process as well. He's saying he basically wants to prejudice the jury by getting them to like his client more, because proximity means they'll like your client more. Is the jury going to like me more because I'm sitting close to him? I don't think that's the case, but it's this quite frankly, it's, in a case like this, it's not something the court should even concern itself with.
Yeah, I'm not concerned, we consider it, if you want. Anything else?
People request that the Alexandra Paul's former career history be excluded as is irrelevant, but could potentially be highly prejudicial.
Your Honor, I would object to that. Background testimony about who someone is necessary for a jury to assess credibility. You know, it's the first thing question you ask is, tell me about your background, your employment, all these things that
Yeah.
Ms. Paul has done. That's just classic
Relevant
background
to
testimony.
this background.
It absolutely is relevant. Yeah.
And people withdraw.
Okay.
Okay, thank you.
All right, anything else?
What time will we be back tomorrow, Chris?
I want you back at 9.
Thank you.
Also, a question about the scheduling. Are you going to be, this trial is clearly going to go into next week. Are we going to be coming back on Monday or Tuesday?
It would be Monday, but it'd be Monday, we'll start at 10 Monday.
Understood, just want to clarify.
Right, so in terms of scheduling, again, except for Tuesdays and Fridays, Tuesdays, we're not gonna start until 1:30. Fridays, we're not gonna start until 1:30, otherwise we'll start at 10 o'clock each day, except for tomorrow. Hopefully I'll get my morning calendar done. And I'd like to start with the third panel of 9 or 9:30 tomorrow, so we can do the hardships and have the third panel join up with the other 2 panels by 10 o'clock.
So we should be here 9 o'clock
Be
tomorrow.
here at 9 o'clock, yes.
Thank you, Mike. One last logistical question. I think this is fine, but I don't think we've ever discussed this, Your Honor. We would like the use of just a legal assistant or 2 on the defense that are not counsel, they'll just sit behind us. I think the bailiff has already indicated that's fine, but the assistant may change over the course of the week and a half.
Not a problem.
Okay, great.
And people would have the same request as regard to our certified law clerks. Thank you.
All right. All right, thank you.
So do you have any thoughts? How do you feel?
Great, yeah.
I think today was a good day.
Yeah.
Today was a good day. So I guess the big thing is, and this is why when we won on necessity a couple weeks ago, I was very tentative with everyone and saying, I don't know if this is going to hold up. And unfortunately, my prediction came true and it didn't hold up. And, there are complicated reasons for that. I think, honestly, even if we had made the public health argument, we probably wouldn't have gotten it. And the public health argument is just less important and interesting, right, than the personhood argument. And, you can see the wheels turning, though. I mean, everyone in the courtroom was thinking about it and asking, okay, maybe an animal is someone else. And why not? And, yeah, the reality is this is not the day for us to win that what will be a historic ruling. But you can see how progress is being made. But pretty much on everything else, I think we won. Even stuff that we didn't expect to win. So, there's some arguments that I thought, given the biases and the predispositions of a court in Merced County, we wouldn't get, that we got. So, for example, the state is going to have to find some way to prove value now at the last minute, because their key witness, they had a high-level executive at Foster Farms, was planning to testify on the first day of trial, and he's gone now. So we'll see how they try and fill that gap, but they're supposed to tell me by the end of the day how they're going to try and fill that gap. But it might be a gap that can't be filled. Getting the advice of counsel / specific intent evidence in. Again, I think we're entitled to it, but it's really important because in Utah, and especially North Carolina, the judge made pretty clear he didn't care what was on our minds, like why we did what we did. And you really can't understand what happened on September 28, 2021 if you don't ask the question why, right? And that was something in Utah the judge very explicitly said, no, you're not allowed to talk about your motive. And it was because he was concerned that if people heard why we did what we did, they'd sympathize. And that's not going to be the case in this court. Right? You are going to be able to talk about your intent, your motivations for what you did on September 28th, and that's big. That's really important because It's going to allow you to complete the narrative, and hopefully will allow the jury to sympathize and understand that you weren't there to take anything of value or steal something commercially from some big corporation. I mean, that would be completely idiotic because these animals are sick. You lost money from doing this. You were there to help someone who needed you. That's it. And we'll get a chance to make that argument in a way that we weren't allowed to make in Utah and North Carolina. So that's a huge victory. I don't know. What are your observations? I think
Well,
both
you
of you
noticed that the
good.
state had to step up. They brought somebody else in
Yeah, they brought another attorney.
because they know that they're facing formidable attorneys who have passion and experience. And you can't just phone it in when you're against people like Wayne and Chris and Kevin. And yeah, they also were caught a little bit flat-footed by not having done work on value earlier and didn't prepare. They thought this was just a petty theft case, and they didn't realize that when you get involved with people who are passionate about what they're doing and think what they're doing is right, you can't just phone it in. You got to bring your A game, which is what we're bringing. I was disappointed that the FOIA reports were not brought in because I think it's really, really important that people know what's going on at Foster Farms, and the fact that there's FOIA reports out there that talk about chickens being mistreated, abominably, burned, scalded alive, being missed on the line because the line is going so fast, therefore being pulled off the line and buried alive under other carcasses. I mean, this is what the FOIA reports say. We're not making this up. This is what the government, the USDA information has, and the state would not let it in today. And I'm sorry about that because I believe that goes to intent. They said that the judge felt that it wasn't necessary because we lost the necessity, I think. But for us, we knew before we saw those FOIA reports, but it backs up what we know about what goes on.
Yeah, and unfortunately what the jury's not going to hear, just so you all can hear what was in those FOIA records, I mean, there's some disturbing shit. And again, this is not us saying it. This is a USDA inspector saying, hey, there's some creepy stuff happening here. But the two things that really leapt out for me from those records are, one, there's an instance where a USDA inspector is present, watching the line in 3 minutes on one line out of 4, just 3 minutes. 24 birds cross the line who have been improperly stunned. We're going to be ripped to pieces, scalded, boiled alive. So that was the first thing. It's like, oh my God, this is like so disturbing. The second thing, and there's just something about the detail of this one. And I almost think, I wonder if this USDA inspector was like an animal advocate or something, because the details provided in this report are really interesting. I mean, interesting is a euphemism. It's disturbing. But so you hook and hoist these animals on the line by the legs, but sometimes they hook them by their wings, even by their neck, inadvertently, because you've got to throw 140 chickens on the line every minute. I mean, you're going to get it wrong. And in one case, they put a chicken in inadvertently, or maybe even intentionally, by their neck, and so their legs are hanging down, where the device called the Cantrell MK3 killer, that's literally the name of the device. It sounds like something from some Predator movie, It's called the MK3 killer. It really does. It sounds terrifying, and it is terrifying, because it's a device to engage in mass violence against sentient beings. It's like a spinning blade that slits the animal's throats. And the idea is they're already stunned, and therefore, when we slit their throats, they quickly die because there's so much quick blood loss that you just basically go unconscious and you die very quickly. But when a chicken is hooked and hoisted by their neck and their heads are in the top, first of all, they just get electrocuted by their legs a little. They're not actually stunned properly. And then what this inspector showed was the leg was severed by the blade because the chicken is squirming, not realizing there's a blade underneath me. She doesn't lift her leg up. Her leg is absolutely severed from her body, except it's hanging by a thread of skin. So this chicken is conscious and alive, watching her own leg hanging from her own body by a thread of skin. And this is detailed in the report. And this is the reason people are fucking outraged by what's happening in places like Foster Farms, why people like Alexandra and Alicia and all of you are trying to stop companies like Foster Farms from torturing and mutilating animals against the law. And the jury's not going to be able to hear that now because of the judge's ruling, which is kind of infuriating. But
we'll get it in
but
next
on the other
time.
hand, this is still way better than better position than we were in Utah or North Carolina. There's still some things that are going to be challenging in this case that frankly were not as challenging in Utah, but still I think we're in reasonable position. We're in reasonable position, and I'm optimistic the judge will hopefully continue to rule in a way that is reasonably fair, which I think he has so far. I mean, other than on necessity, but from a mainstream perspective, I understand how a judge would say a chicken is not someone. We're not there yet. We will get there. But we're not there yet. He did think about it. He thought about it. Yeah.
Maybe
Any
we know what
questions
the
or thoughts?
signs need
Wow.
to be out here.
Who drew this?
Chicken is a someone.
This is fucking good.
Katya.
Kaya?
Katya.
Wow.
Amazing, Kaya.
Wow.
Look at this.
Oh,
You look.
great.
Chris. It's beautiful. Thank you, Kaya.
Could I take a picture of it or
Please.
get a copy?
So anyone have any questions or thoughts?
Put it on your fridge.
I like the other side saying a chicken
Who?
Oh, did they say that?
Did you hear him
That's
say the chicken labeled as Jack's? He
Labeled.
started to say named.
calling him Jack, and then he goes, I mean the chicken labeled as Jack.
Yes.
That's such a weird way to say that too. Labeled?
Exactly.
I know this is a tall order, but is it possible in like less than a minute to give sort of a quick summary of the important or imperative
Yeah,
motions?
I can do